Good morning, everybody, and welcome to the first in this series of webinars from IMAP on MDAs. What we're going to be covering through the course of this week is a series of the technical issues around operating an MDA service as the MDA provider or as an MDA advisor. So through this week, we'll be running a session today on insurance, tomorrow on fiduciary duty and what that means. On Wednesday, identifying and managing conflicts of interest within an MDA program. Thursday, we'll be looking at fee disclosure and what the obligations for fee disclosure are. And then on Friday, we'll have a session on the strategic issues around managed accounts generally, particularly from the perspective of being a licensee. This is part of our MDA 360 program, which is sponsored by Mason Stevens, and I'll introduce Charlie Green in a moment. So as well as this webinar series, we're going to be running a series of masterclasses, full-day in-person sessions in October on best practice advice for MDAs. November, the Responsible Manager program, which we've run previously. And in December, a risk management masterclass. So risk management frameworks for MDAs. As many of you will know, ASIC will be rolling over the MDA instrument in September to go live on the 1st of October. And while we're not sure yet what the changes to the instrument will mean, we will be hosting a leadership summit on the 19th and 20th of November, the day after the Responsible Manager Masterclass, for MDA providers and advisors. And at that summit, we'll be dissecting the changes that ASIC has implemented. This program is really, the MDA 360 program is made possible by the participation of a large number of leading practitioners from specialist areas associated with MDAs, in particular partners from law firms. But today, for example, Stephen Hughes from AJ Gallaghers, a leading insurance broker. For one of our masterclasses, Jane Zoe from Acambo, their head of compliance. This program is made possible by the support of Mason Stevens, and it's now my pleasure to introduce Charlie Green, Sales Director for Mason Stevens, to say a little about their involvement in MDAs. Charlie, over to you.
Beautiful. Thanks, Toby. And thanks to everyone attending the session today. We're really proud to be partnering with IMAP for this webinar series to demystify the finer points of establishing, managing and advising clients under an MDA service. So very briefly, for those not familiar, Mason Stevens is a platform that's been at the forefront of MDAs for over 16 years. It's the only wealth platform in Australia with integrated MDA offering. We think we understand pretty well what it takes to deliver an exceptional managed account experience, and that's at the portfolio manager level right through to the end client. And that experience runs deep. So the majority of portfolios on our platform operate under an MDA. And this really drives how we've developed our service proposition and platform technology, which is dedicated to ensuring that service works seamlessly for all of our partners and their clients. We're a team of investment and markets people, so we understand what it takes to deliver that exceptional investment outcome. So whether or not you're using, say, our live trading desk, assisting with governance, investment committee frameworks, providing IC representation or analytics and reporting, we've sort of built out a suite of services that enables our partners to deliver the best portfolio outcomes for their clients, particularly in the wholesale and high net worth space. So for now, that's enough from me. Please reach out if you'd like to chat about how we could assist. But for now, I'll hand over to our panelists to start the session today.
Thanks very much, Charlie. So all of this week's webinars and the masterclasses will be available to you as well through our IMAP Connect online learning system. All of the webinars are CPD accredited, and you can also achieve CPD accreditation by following them on IMAP Connect. So now it's my pleasure to hand over to Jesse Vermiglio, partner of Holley Nethercote, to take us away on PI insurance. Jesse, thanks very much.
Thanks, Toby, and thanks to IMAP for the invitation to speak on MDAs and PI insurance. I guess before I start, and I'm conscious that sort of Stephen will jump in, certainly from his practical perspective on claims and claims handling, but I probably just want to start by setting the scene in relation to PI insurance requirements with an eye to maybe what might change with the rollover of the relief in the not too distant future, and maybe just sort of set out some of the technical differences between, let's say, PI insurance requirements under the MDA instrument compared to generally what the PI insurance requirements are under RG 126 or other financial services. But probably I'll first start by saying sort of why do we need PI insurance, and I'll just might make a couple of observations there around PI insurance, and then talk to the technical differences between PI insurance in the MDA or under the MDA instrument and more broadly under the FSR regime. I don't think you can talk about PI insurance without talking about risk management. In essence, PI insurance is effectively risk management, but mandated risk management from the perspective of AFSL providers. It is a requirement of AFSL holders. So, but I say that not just in identifying what the risks of operating MDAs are, or for that matter, advising in the MDA space. And I'll make some observations that are about both the risks that are specific to I'll use providers, MDA providers, because it's the language of the class order or the legislative instrument, as compared to MDA advisors, essentially those that recommend an MDA. And from that, we'll then sort of finish off by some sort of key takeouts. But maybe just starting with PI insurance and why we have PI insurance. Essentially, when you try to sort of understand what the policy intent of mandating specific PI insurance, it really is to ensure that it is a consumer protection provision. It ensures that there's sufficient funds there to be able to provide financial resources in the event that there's clients suffer loss from, in the case of MDAs, the management of their client assets under an MDA. And in addition to that, there's also this added element to it that from the legislative instrument anyway, identifies sort of the misappropriation or the misuse of those funds, because obviously there's discretion that is exercised over those funds. So there's a heightened risk of misappropriation or misuse by those that are operating MDAs. And so that, in essence, becomes the rationale, sort of consumer protection, and with the added aspect of the discretionary trading that sort of leads us to what those requirements are. So this might be a good opportunity just to move to what those requirements are. Look, at a very high level, what I've tried to do is sort of side by side give you a bit of an idea of what the PI insurance requirements are in relation to both MDA providers and essentially advisors. And we start with maybe the source of law. Those who are in the advisor space is probably familiar with RG 126 and Section 912B. They are predicated, and the regulation for that matter, that really sets out the requirements in relation to PI insurance for financial advisors or financial service providers more broadly. Importantly, in that regime, there is a level of specificity that exists in the general financial services regime that really does not exist with respect to the PI insurance for MDA providers. And by that I mean it is legislated that, firstly, PI insurance, and this is consistent with both regimes, that both PI insurance regimes need to, or the covers need to be adequate. But in relation to financial services more broadly, that adequacy is a function of the nature, scale, complexity of the business, having regard to a number of factors. They are the volume of the business, the number and kind of clients, the kind and kinds of businesses operated by the financial services provider, and the number of representatives. That's legislated. That's for the purpose, if you were to go to section 912B in regulation 7602 AAA, you'll find those parameters there. Obviously, then we look to section 126 to tell us what adequacy is, or what adequate is. In relation to MDA providers, that is a slightly different proposition. We need to go to the legislative instrument. The legislative instrument sets out what is mandated for MDA providers, and unlike RG126, it does not have the extensive laundry lists of inclusions, exclusions that regulatory guide does. That regulatory guide was, we might just go back still one slide if that's okay. That regulatory guide was 126 was it took some time to consultation back in 2007, 2006 was quite extensive. There's an external report commissioned. And so all those lists of factors in there really result from that consultation process and that commissioned expert advice. But ultimately, the significant difference between the two is you'll see there that for the MDA providers, there is a different amount or minimum amount of cover. That is, for the purposes of MDA providers, that is covering claims amounting in the aggregate of the lesser of $5 million or the aggregate average value of client portfolio assets of MDA clients, as compared to, so that's sort of the lesser of 5 million or the aggregate average value of client portfolio assets for the last 12 months, as compared to RG126, which is at least $2 million or total revenue from financial services up to a cap of $20 million. And in RG126 territory, you've either got the ability to rely upon actual or expected revenue, or if you've got some changes that you are consider that there is to your business that is about to occur. Whereas with PI insurance for MDA providers is a retrospective test based on the previous 12 months. Both PI insurance regimes, or put another way, the requirement to hold PI insurance is about retail client losses. So for there to be financial resources to cover retail client losses. So this is not a wholesale client requirement. This is a retail client requirement. That said, though, certainly some policies that I've seen extend to both. So being aware of what you're paying for is often a really important aspect. I talked a little bit about adequacy, but there is not the distinction between or the extensive list of exclusions and inclusions that RG126 has. In RG179, or in the requirement that's in the legislative instrument, really the basis of what the policy should look like is based on it being adequate in regard to the nature of the activities carried out by the licensee in relation to the MDA services. So whatever those risks and whatever is considered adequacy as a result of the MDA services is really where what is required, obviously based, and then overlaying that with a minimum cover. Maybe if we can go to the next slide, I'll just quickly walk through just some certain things. Now, there are some specific inclusion exclusions, specific cover. PI for MDA providers, PI cover has to include cover for fraud by its officers and employees. For slightly different in RG126 or for financial advisors more broadly. There are minimum requirements for loss or damage because of Chapter 7 more broadly, but also it includes fraud and dishonesty and AFCA awards. That language is missing in the requirements for MDA providers, but when you go back, and a lot of these differences, I don't think are significant. In fact, I think when you overlay the requirement for the PI insurance to be adequate, you would find that certainly at least, the laundry list of requirements that are in RG126 would likely apply to the MDA providers, even though the legislative instrument is silent on those things. So, for example, the legislative instrument is silent on the list of exclusions, and anyone who's engaged with RG126 knows about certainly the list of things that cannot be excluded from a PI insurance. None of those things are specified in the instrument, but again, when you overlay with adequacy, you need to ask yourself the question whether or not with those exclusions, the policy could be adequate. Automatic reinstatements, certainly RG126 specifies at least one reinstatement. That would be interesting to understand whether or not a policy would not be adequate if it didn't include at least one reinstatement. Again, it's absent that requirement. ASIC does say that in relation to excesses and deductibles, licensees need to understand the nature or that they're able to sustain that uninsured loss. So obviously the higher the excess, the more able you have to be to sustain that loss. Again, silent in relation to MDA providers, but question whether or not it'd be adequate to not be able to sustain it. I would imagine that would be the case, and that would be the way that ASIC would interpret it. Finally, defence costs must be in addition to the minimum requirements for RG126, not the same for MDA providers, or it's silent on that, and no retroactive cover, or silent on retroactive cover, but that is provided for an advisor. So again, it is a different legislative scheme for PI insurance for MDA providers. That's largely coming out of the regulation that is as to how MDA providers are regulated. And that's probably why we have that difference. So I might talk a little bit now on the distinction between those two. So the aspects of MDA regulation, I think this is really important to understand, and it doesn't really just apply to PI insurance, but rather the legislative framework or the regulatory framework for MDAs really comes from the nature of the work that you are doing. The discretionary training the MDA providers are providing as part of that does certainly heighten the risk of the financial services, and as certainly that in my experience in the eyes of the regulator, but also that feeds through in terms of the types of standards and requirements that are in the legislative instrument. So for those of you obviously who work in this space and dealing with it all the time, you're familiar that there is a tailored MDA legislative instrument, previously called a class order, which regulates the provision of MDA services. And what it has done is it effectively has tailored a scheme that is similar to the managed investment scheme regime, but tailored specific to the risks of MDA providers. There was an acknowledgement many years ago that certainly from a licensing perspective and other obligations perspective, that a lot of those obligations didn't apply. So the legislative instrument, which is very lengthy, is really one that tailors, essentially turns on particular obligations that are specific and tailored to the risks associated with MDA the MDA services. The legislative instrument is one that is specific to retail clients, and obviously there's a significant, it's a very topical area at the moment, real distinction between AFCA and ASIC about what, or ASIC's traditional position on wholesale clients in relation to, just generally in relation to SMSFs. So it's a real important one, but critically, the legislative instrument is one that just applies to retail clients, hence the reason why the PI insurance cover requirements are retail client specific. Relief from various Corporations Act requirements, and importantly from the licensing requirements, from the managed investment scheme requirements around licensing, but also about registration of retail schemes. Again, with that comes enhanced disclosure requirements, both on the FSG side, important disclosures around the investment program or investment mandate, and also the MDA contracts, very, very prescriptive requirements in relation to those documents. Upfront and ongoing obligations around suitability. I think, if one was to do a word search about suitability or suitable on in relation to the MDA instrument, I think you'd find something like 13 or 14 references. So it gives you an idea of how important suitability is. Again, it goes to the complexity of what MDAs are. And so ensuring suitability becomes a very, very important policy objective. And in fact, there's a separate breach reporting regime within the legislative instrument that's separate and distinct from the reportable situation regimes that sometimes people forget. So that just sort of gives you a high level idea that here you've got a very specific tailored regulatory regime for MDA providers. I might just move to some of the risks that we've sort of been presented. Look, there's a whole laundry list of risks there, and I'm conscious that Stephen might sort of make some observations about some of the claims that relate to some of these. But I did mention, I won't go through all of these in detail, but I might just mention a few. But certainly these are the ones that come up when thinking about risks of operating or advising on an MDA. Wholesale client versus retail clients. As I mentioned, there's quite a significant or quite topical at the moment that the tension between ASIC's traditional view about SMSFs as well as what AFCA's view are. For those of you who are not familiar with that, ASIC traditionally held a view that trustees of an SMSF could be considered to be a wholesale client using, for example, the $2.5 million asset test or their income tests, provided that the advice related to the underlying investments of the SMSF and not to the setup of the SMSF. That position was communicated in a media release, I think in 2014 from recollections some time ago, and it was a way in which the industry had been thinking about the wholesale retail divide, particularly as it related to SMSFs. For those who are unfamiliar, there are 5 categories of wholesale client classifications, and one, the accountant certificate with $2.5 million in net assets, but also or an income test as well, $250,000 annually can get you into the wholesale client space. There's a product value test as well, the $500,000 product value test, but there are also a suitability test or an assessment test that the licensee can do. But predominantly, most of the action has been in that $2.5 million or $250,000 income test where that has changed. Be mindful of that. It's that AFCA has taken now the view that for SMSF trustees must have at least $10 million to be considered a wholesale client. So if you are you need to be mindful of that risk, that is ASIC, that is AFCA's position, and until we have a sort of a court decision that sort of determines who's right between ASIC, although I must admit ASIC has been decidedly silent on it. So I think the safe harbour test there, or the safe harbour there, is to treat SMSF trustees as retail unless they've got $10 million or more in funds under the SMSF. Suitability is key. That is really, and that's suitability of the MDA, whether it's upfront, whether it's on an ongoing basis annually. The need to ensure on an ongoing basis and before the client gets into an MDA that an MDA is suitable for them is of great significance, because, as I said, there is many opportunities where suitability will be tested. And so constantly ensuring that what they have, including whether or not their investment program remains suitable, is really important as part of that ongoing legislative framework or legislative scheme. Conflicts of interest often become a major issue in this space. Oftentimes there are interests that either the advisor and or the MDA provider might have that are in addition to the services that they provide. And there is a conflicts prioritisation rule that not just for advisors, but also for MDA operators. Overlay that is obviously the best interest-like obligations that are akin to the trustees of managed investment schemes that also apply to those that are operating MDAs. So conflicts of interest, and we'll be talking a little bit more about conflicts of interest on Wednesday, become a really important area Investments not in line with the investment program. That is one. Certainly, there are AFCA cases that look at that, whereby really the mandate has not been followed to the T, and it's a very, very easy win for someone in AFCA, particularly if the investments that have been placed or executed are not in line with that investment program. High risk strategies, certainly there have been cases around uh, operating really highly leveraged complex products or complex strategies using an MDA, and very easy for them to come a cropper on those, and particularly in circumstances where they're being characterised as wholesale clients, and that hasn't been done correctly. I might very quickly outsourcing. Obviously, there's a big focus by the regulator on outsourced providers. So, to the extent to which any of your services are outsourced, having a clear understanding of what's been outsourced. Again, you can outsource the service, but you cannot outsource the responsibility. And so, making sure that those protocols, practices, measures are in place that whatever your outsourced provider is doing, that you've got total confidence that they're doing so in a manner that you're comfortable with. I might say something a little bit about AI and cyber. Firstly, on cyber, we're now 4 or 5 years into what is a very certainly a very aggressive approach for the regulator about taking cyber incidences and taking regulatory actions in relation to those. Having been involved in many of those, certainly the expectation is through adequate risk management and sort of general obligations of efficiently, honestly, and fairly that there are measures in place that protect particularly personal information of your clients. And so certainly that's an area that has really significantly increased in what is expected in terms of those measures. So a number of cases, whether they be RI advice, whether they be the FIG securities, HSBC. I'm conscious that there's also other cases, or another case through the courts at the moment, whereby those standards are being tested. Importantly, the regulator has said in the past that they are looking to take action in relation to individual directors. So we haven't seen any of those yet, but I expect that certainly given how strongly they've come out on that would be probably the case in a not too distant future. And then with AI, the automation of a lot of trading, and certainly I see a lot of propositions or potential business models that come past my desk seeking advice using automation, agentic AI as a way to enhance sort of clients' trading experience, and then how that is, and that how that certainly the safeguards that are around that. I will say there is a governance. We're still pretty light on in terms of governance frameworks. Obviously, ASIC has been quite vocal in terms of what it expects in terms of governance on AI, and certainly the government has also indicated a bit of a roadmap there about regulation of AI as well. Again, thinking about it through the existing prism of obligations, the general obligations, thinking about risk management. So if you're utilizing agentic AI or any other forms of technology to enhance sort of trading experience or make things more efficient for you, obviously having overlaying a sort of a governance framework and a risk management framework that identifies the risk, particularly about the risk of misuse of client information, is going to be critical. Maybe look with that very quickly. Clients don't usually, certainly although I've been involved, my experience is clients don't really read their PI insurance policy until they really need to, but take your opportunity on renewal to understand exactly what is there and what's not there. You might find that there are things that are missing that really you should have in terms of cover. I'm sure Steve will talk to that briefly. Also know the services you provide in relation to MDAs. That might sound pretty trite, but are you an operator? Are you just an MDA advisor? Are you both? And what type of obligations then apply to you? Is it the legislative instrument or is it the general financial services regime? Understanding the specific risks, not just client liability, but also regulatory risks, compliance risks, really key to help you then build out an effective compliance framework. And then regularly review not just those procedures, but also your PI insurance cover. Again, I say that establishing an effective compliance framework can help you immensely, particularly when negotiating PI insurance, but also to avoid the need to rely on PI insurance. Over to you, Toby.
Great. Look, thank you very much, Jesse. That's a great introduction to PI. We've had a number of questions come through already, and I know they are really apposite questions. So if you have questions coming out of Jesse or Stephen's presentation, fire them in the Q&A, and we'll leave some time at the end of this to address both of those. I won't do them now because I know some of the questions that have been asked will be answered by Stephen. So it's now my pleasure to hand over to Stephen Hughes from AJ Gallaghers. Stephen, thanks very much.
Right. Thank you, Toby, and thanks, Jesse. So as Jesse has highlighted, there's a number of PI requirements and compliance issues faced by MDA operators, and I want to just go through and give some practical claim examples of those exposures and how they relate to your professional indemnity insurance, and also perhaps more broadly cyber risk. It's no secret that MDA operators face a very different risk profile to the traditional financial advisors because of that ongoing discretionary decisions that they're able to provide on behalf of clients. And with technology evolving the way it is, that will only increase. With AI and automation, this trend is bound to continue. And one theme you'll see through today's examples is that largest MDA claims are really caused by the actual investment itself falling, although markets falling can expose underlying issues. And certainly, before the GFC, we actually saw very few claims, and then we had the GFC and we were just bombarded with claims. I think on my own portfolio, there's something like 50 million in claims paid out. And usually it's the underlying issues, the governance failures, suitability is a big one, which Jesse has talked about, client classification problems, poor oversight. And remember, you have a increased accountability, a sort of higher fiduciary relationship as an MDA operator. So if we can go to the first example. So in terms of, this was a husband and wife, they clearly fall within that sort of wholesale distinction, categorization under the Corporations Act, because they were, she is a medical specialist and he an IT manager. They earning well over 500k or whatever it might be, but they held an industry super fund, and they were recommended into an SMSF via a MDA structure, and there was a dispute over they felt that they were sort of told that they nothing would really change, but it would be a more streamlined process being under a wholesale arrangement and being under an MDA. It's a good example of how an apparently simple advice arrangement can create a significant dispute. Jesse did touch on this issue of industry of SMSFs and AFCA's view on SMSFs, which is basically that if the SMSF itself is bringing a claim, then really you could be classified as retail up to if those investments held under that structure are under 10 million, which should send off alarm bells, because that's very significant. The key point really is AFCA may review, once they sort of determine that classification is incorrect, they can look and review years of discretionary portfolio decisions rather than a single investment recommendation. Again, this is a key point because when we went through the GFC, it was more a traditional model there, and you had, let's say, basis capital collapse, and the FOSS at the time looked at that investment in isolation to the portfolio, whereas under an MDA, they can expose all those years of discretionary the whole process, and that can evolve into much more and significantly higher claims. If we can go to the next example, please. So this claim demonstrates how how multiple allegations can develop through a single sort of investment strategy. At face value, it appeared to be complaint about losses using leveraged foreign exchange strategy. That might be, we're seeing what's happened in Korea, and all these foreign hedge funds, leveraged funds, is quite topical. However, AFCA focus quickly expanded beyond performance and into client classification and suitability. Once AFCA concluded the client had been incorrectly classified as wholesale, the entire advice process became open to scrutiny. That they examined whether the strategy was appropriate, whether the risks had been adequately explained, and whether regulatory obligations had been met. So the lesson for the MDA operators is that classification failures frequently increase claim severity. What begins as an investment loss complaint can rapidly become a broader governance and compliance case. If we can go to the next slide, please. I thought it would be useful. Jesse was talking about, the looking at your PI policy and where exposures might be and how the policy might respond. So the typical sort of exposures for an MDA operator, the big one that we've been talking about, is that wholesale client classification. So really, that's generally should fall. The PI policies don't really distinguish between retail and wholesale, so I shouldn't see that should be an issue. The product not being approved or approval process not being followed. Some of the policies have APL, approved product list exclusions, which can be worded in such a way that they can remove cover for product governance type processes that haven't been followed. I think the better ones, or the preferred ones, are where they talk about investments being approved if they're if they meet a criteria, like if they're investment grade or above from a Morningstar, one of those, and then you've got your own research investment committee that would do their own research. But it is worth, if you're doing your renewal, make sure that the broker is telling the underwriter how your product list or works, or in terms of your approval, your investment committee, so that the insurer is familiar with that. One of my pet hates is the conflict of interest exclusion under PI policies, and how this can be used by insurers as an escape out of jail sort of card. And it has, we've had, under the IG 126, you've got to cover fraud and dishonesty, but we've had a claim decline, this is going back many years, where there was a conflict of interest exclusion, and it involved fraud by the advisor. Obviously fraud is going to be a conflict of interest. So, and the way they worded, some of them are better than others. Some just deal where it's actually found to be a conflict, but some of the wordings can say arising directly, indirectly, in any way associated, or arising from a conflict of interest. So you should check that. Related party investments, I'm not sure if if you are doing related party investments, there are often related party exclusions under the policy, so that's something to look at. High leveraged, high risk investments. again, when we had with the GFC, it was all those illiquid type products. When there's a massive fall in the market, those sort of products are the first to get frozen, don't pay redemptions, and inevitably claims are made from dissatisfied clients. So you might want to just check that you've got, if there's any investments, unlisted investments that, or, they all have crypto exclusions as well. So you'll just check that you've got, that there's cover there. Portfolio drift, that shouldn't be an issue. That's a typical sort of negligence type claim. Investment mandate breach. So again, that shouldn't be an issue. It should be cover should be available. Outsourcing is an interesting one. Insofar as as a MDA operator, you retain that responsibility under your license. So just make sure who you're outsourcing to. We've had claims. There's also exclusions under PI policies for assumed liability under contract, and we've had claims. I had one for $500,000 declined because a licensee took on risk that the insurer wouldn't have been exposed to in the absence of the contract. You don't want to be taking on liability that sits outside your profession. So it's different if it's because you referred someone to someone who was inadequate. That should be fine. But if suddenly you're exposed to a claim that should normally be an accounting claim or a real estate claim or one of those type claims that would fit outside the policy, then you're going to, or claims from bringing a new car into your business, and then that can be an issue when you've taken on the liability from the prior licensee. So trading errors that should normally fit within the policy. Multi-year portfolio management. This is an interesting issue that's come up over the years, and it's you should always have insurance with a retroactive date that goes back to when your license was first established. You might, with advice, with financial advice, you give it financial advice. There's a big lag between when you give that advice and when claims can arise. So, and what can happen, particularly with, you've moved from one insurer to the new insurer, you still have that unlimited retro cover back to when you originally started. But the new insurer will exclude any known claims or known circumstances at the time of moving. And the known circumstances one can be a real catch, because if you've moved insurers getting a better deal, whatever, and the new insurer says, well, we're excluding, and you have a claim that relates to advice 5 years ago, the test is going to be whether you knew or ought to have known that there could have been a potential claim. So if you stay with the same insurer, that sort of test doesn't arise, or if they give you backdated continuity, then that's okay. Jesse also talked about checking on your excess, which is important because sometimes, let's say it's a collapsed fund, insurers will treat collapsed funds generally as separate pieces of advice for each client, because you have to take each client's circumstances into account. So you might think you've got one excess applying, and you might be happy to take a higher excess of 50 or 100 grand, but then if you have 10 clients each complaining with separate complaints, that could actually end up being 10 separate deductibles. And fee disclosures are a common one, and just to highlight that fee disclosure is not really covered under PI, because it's refund of fees or something. You've already got the benefit of the fee. The insurer won't be there to save you to refund fees. Okay, could we have the next slide, please? In terms of the cyber threat landscape, there's a big one. We often get people saying, licensees saying, we've got very good controls, we've got this and that, we don't really need cyber. But most 95% of cyber threats happen with human error rather than sophisticated hacking. Someone just clicking on an email that they shouldn't have, and And MDA operators are obviously a huge target. They hold highly sensitive and financial and personal information. They effectively act as custodians for both assets, client assets and information. And they're basically attractive targets. You can see the trend. I mean, you know, in the news all the time that how many claims are coming about from cyber events. So yeah, if we can go to the next slide, please. In terms of the incident response, so that this is where it does become a critical issue for cyber insurance, because what we've found is that cyber events are so foreign. It's such a, no one really knows what to do. Even the large companies aren't that aware of how to treat a cyber event. And so having an incident response process in place is really critical, because the quicker you get onto these claims, the quicker they're resolved. If you leave a cyber event over 48 hours, then you're often in trouble because the intruders got into your software and done all sorts of weird and wonderful things. So the key, and if the incident exposes a weakness that is likely to cause a significant breach of the AFSL conditions, then you obviously got an obligation to report that within 30 days. If we could go to the next slide, please. So I just want to highlight that, sometimes people say, why do we need cyber when we've got professional indemnity? So those first four incident response costs, extortion, business interruption, data asset restoration, you're only going to get that under a cyber policy. And one of the critical things is the incident response. As I say, these guys live and sleep cyber. They're in the dark web. They often know the cyber actors that have hacked the system. So and so all those first party where you yourself are claiming on the policy, the third party claim is a typical liability type claim where you've got coverage for lawsuits and business partners affected of individuals for privacy breaches. If we can look at the role of the Privacy Commissioner, just to highlight there that privacy obligations, continue to expand, and many businesses incorrectly assume they're exempt due to their size, but organizations handling sensitive information still have privacy obligations, and the eligible data breaches will trigger mandatory notification requirements. Financial service firms largely, obviously, hold large quantities of personal and financial information. If we go to the next slide, please. And I guess the RI advice is one of the most important cyber cases for AFSLs. The federal court made it clear that cybersecurity is not simply an IT issue, it is a governance and risk management issue. So ASIC expects licensees to actively manage cyber risk and oversee service providers and representatives. So I wanted to just talk then about, we've got all this talk about AI and emerging risks. So if we can just, if you can go to the next slide, please. So this is a rapidly evolving risk area, well, for MDA operators and all AFSLs really, in fact, for all businesses really. Traditional software follows instructions. Agentic AI can make decisions, initiate actions, interact with other systems with limited human intervention. We are already seeing AI being explored for portfolio monitoring, research, client communications, compliance functions, The challenge is governance. If an AI-driven process causes harm, responsibility still sits with that licensee. The key issue really is how firms maintain oversight of their AI-driven decisions. So you can imagine, like, if you had an AI portfolio management tool which acted on corrupted market data overnight, executing thousands of functions before anyone noticed, that potential dispute could involve your professional indemnity policy, your cyber insurance policy, and potentially also your director's insurance, involving failure by directors to fulfill their duty, fiduciary duty as directors, in terms of their governance responsibilities. So, and also just to talk a bit about the cyber policies, the insurance policies themselves, because this has been an area that's evolved so quickly. So, you know, it is worth looking at your cyber policy or checking with your broker whether your cyber insurance policy does extend to cover cyber events. So, and a cyber event means actual, I'm just going to read out from one of the insurers' wordings here, means actual or suspected unauthorized system access, electronic attack, or privacy breach, including an attack that utilizes artificial intelligence. That wording is important because many of the cyber policies are silent on AI. So, so I think it's something that's worth checking, particularly as it's such an evolving landscape. So cyber insurance can respond where the AI creates a cyber incident, privacy breach, funds transfer fraud, or system outage. It generally, though, does not replace PI insurance where the allegation is around advice, investment decision, or portfolio management itself, where those were wrong, or where that's where the dispute lies. If we could go to the next slide, please. So just to go through the steps in the claim process, and to highlight that it's really important to immediately report any cyber incident. The quicker you do it, the better. If you do it quickly, as I say, the insurers have extremely competent incident response teams, and they know that they've got to get onto this quick. And if they can get onto quick, then you can get to a point where you don't have exposure. And we've had all sorts of exposures with cyber. We've had one where the advisor was doing progress payments for a client of his to a builder, and the client was building a house, and those progress payments, the builder's email was hacked, and so the progress payments weren't coming from the builder, but they're coming from the hacker who got into the builder's email. We've also had things like if they get into your system, they create false emails. They start emailing all your clients. We've had one where the advisor number was obtained through hacking, and then the hackers got onto the platform that the advisor was using and started changing all the mobile numbers of the clients on the platform. Unfortunately, the bank noticed this, and it was stopped. But so the quicker you get onto these things, the better, basically. And you can see that there's a lot of the insurers, they'll appoint a forensic investigator. They assess that the claim is covered. Sorry, could we just go to the next slide? There's all these parties that are involved to assist you in the event of a cyber incident. It might involve legal counsel. Crisis communication will be really important if you've got any potential any potential breaches, and if they, often they're after a extortion, so they would be asking for ransom, and so you have the ransom negotiators that engage, and they do it. Usually they'll give 3 numbers and 3 more and 3 more until they get the outcome. But ransomware is covered by the policy, and it's usually the insured's decision if it wants to pay the ransom or not. So I think and then obviously the IT systems being restored and data recovery initiated, and back to business as usual. And there might also be a business interruption claim. So that's it from me. Thanks, Toby.
Thanks very much. Well, we might, Jesse, if I get you to put your camera on, and we might just address some of the questions that have come up through the session. So to both of you, does one policy cover being an MDA provider and giving advice? Would you expect to see that in one policy or 2?
Yeah, that is a good question, and that you've got the advisor who's also the investment manager. So basically, that can be covered in one policy. You just got to make sure that is appropriately worded, that there's no exclusions between those functions. But we are in a softer market where insurers might do things that they didn't do in the past, and so really there's a much friendlier market for MDA operators at the moment.
Yeah, I agree with that, and you might, for those wanting some sort of cover for that, there's a note in RG 179 that does say that the same insurance can be relied on to meet both the RG 126 and RG 179 requirements, or under the legislative instruments. But importantly, make sure that you've got the cover. So if your MDA policy is only limited to the MDA service, but you're doing more than the MDA service, obviously you will need other cover to cover your other financial services.
Okay. This question was probably inspired by Shield and First Guardian. Insurance against fraud is only at a proprietary level, employees and officers, and not applicable to fraud through investment scams. So I guess the question is, does an MDA provider with a PI policy have any protection against, or need protection against, fraud in underlying, in underlying investments?
Well, I'll give my answer, and then Jesse can come back as well. But I mean, it's working on a civil liability basis. To what extent is the insured, being the AFSL or the advisor, legally liable for the loss that the client has incurred? So there would have to be a liability attaching, because the insurer would likely argue, well, there's no legal liability attaching to the advisor. How would they have known that the underlying fund manager was fraudulent? Or they'd have to attach a liability saying, well, advice company, you didn't do your proper due diligence. Why did you put this product on the APL? It should never have been on the APL. And that's the way they can attach liability to the advisor. But if you say just on the basis of pure fraud, and let's say it was very hard to detect, and then it's quite difficult. Then you have to attach some form of liability to the AFSL or the advisor for the policy to respond.
Mm-hmm. Yeah, I agree with that. I mean, generally speaking, this has been not so much in the context of investment scams, but more broadly in the past, sort of a bit old territory. ASIC certainly mandated that the licensee, the PI insurance policy should cover fraud of individual advisors or individual representatives. So obviously where that's in circumstances where it's done without their knowledge. And in the past, sort of certain wording would have excluded that type of cover, but certainly as a result of RG 126,
So I guess if I was a lawyer acting for a client who'd lost money, I mean, the argument I'd be putting was exactly the one you mentioned, Stephen, which is, well, you should have done more. The MDA provider and potentially the advisor, if they weren't one and the same, should have done more operational due diligence.
That's right. I mean, so the policies, as Jesse says, they do all have the fraud and dishonesty extension now to comply with RG 126, but you can't actually insure a criminal. You can't insure the advisor who's been dodgy or the fund manager that's been dodgy. But you're insuring the innocent party, which would be the civil liability for the AFSL for recommending that product that should never, if they'd done proper governance, should never have been on the APL or something like that. So that's where liability will attach.
And don't forget Section 917F, which makes the licensee responsible as between the client and for any financial services that have been provided by anyone, whether or not. And even if there's aspects of fraud, I would imagine that section would be engaged to sort of find liability or attach liability or try to attach liability to the licensee in those circumstances.
All right. Look, we've used up our time, so I'll leave the last question, which technically had to do with the aggregate average value. So, look, Stephen Hughes, Jesse Vermiglio, thank you very much for your time today. It's been an insightful presentation in what I think is probably a too little understood area of advice and MDA operations. So thank you for your time. And to those of you on the webinar, a reminder that for the rest of the week we'll be running 4 more webinars on different aspects of MDAs. And then 3 masterclasses and the MDA Leadership Summit in November, all leading up to the release by ASIC of the MDA instrument in mid to late September. So Jesse, Stephen, and Charlie, thank you very much for your time, and we'll look forward to seeing you all tomorrow.
Thanks, Toby. Thanks, everyone.
Thank you.
Thanks.